Hello, everyone. Thanks for joining us. We're talking about disclosure traps for the unwary, selling or buying a house, otherwise known as the Form 17 or the seller disclosure statement. So, what is a seller disclosure statement of Form 17? It's a six-page document that's given by the seller to the buyer at the outset of a transaction, sometimes posted by the real estate agent in the notes of the listing for everyone to see. So this is the document. If you've bought or sold real estate before, you're probably familiar with it, where you, the seller, are disclosing information about the condition of the property, given away by a whole bunch of boxes that say yes, no, I don't know, or not applicable. So these are broken down into categories of disclosures: title, water, sewer, septic; structure, systems and fixtures; HOA issues, sometimes applicable, of course, sometimes not; and then environmental issues. So we'll go through these one at a time briefly, and then talk about the pitfalls in avoiding them for both buyers and sellers. So a buyer can sue their seller for a breach of the Form 17. It's a statutory claim. The Form 17 is not a part of the purchase and sale agreement. It's its own thing. And the statute itself does not have an attorney's fees clause in it. The statute says it just doesn't have an attorney's fees clause, meaning that uh, in a lawsuit, by default, normally everyone would pay their own attorney's fees regardless of the winner. But the purchase and sale agreement contains an attorney's fees clause, meaning that in a lawsuit over the purchase and sale agreement, the winner would have their attorney's fees paid by the loser. Um, but you might say the Form 17 is not part of the purchase and sale agreement, expressly not part of the purchase and sale agreement. It is a creature of statute. Nonetheless, the Washington State Court of Appeals has held that the attorney's fees clause does apply. The purchase and sale agreement attorney's fees clause applies to Form 17 breaches, which definitely changes the analysis. About the advisability of a Form 17 claim, specifically where they might not have been advisable. They're more advisable now than they used to be. So we're going to go through these frequent issues for the buyers that we touched on the first slide. So title, you might have encroachments onto the property. Those encroachments can ripen into adverse possession or prescriptive easements. That means obtaining an ownership interest in a piece of property because you've held on to or you've held on to possession of it for over 10 years. There's a lot of adverse possession and prescriptive easement blog posts on our firm's website. Feel free to poke around and you'll find a lot of those for a better description of adverse possession, prescriptive easement. You can also, through a title issue that the Form 17 asks about, you can also create non-conforming lots through adverse possession or prescriptive easement or any encroachment, meaning your lot has shrunk, creating possible setback issues for future developability, maximum impervious surface coverage issues, and those nonconformities. Examples of those nonconformities are setbacks and max impervious surface coverage. Those nonconformities can prevent future development. So those issues are inquired about by the Form 17. Another common one is septic issues and lots of situations where the buyer buys and you've got an improperly functioning septic system. And frequently there's evidence that the seller knew about it and failed to disclose it in the Form 17 or actively misled through their answer in the Form 17. Again, environmental issues also pretty common. So you have what we call USTs, or underground storage tanks, for heating oil, and a lot of houses in the 50s and 60s, 40s in the greater Seattle area were built with underground storage tanks with heating oil. there was a whole category of those tanks, especially in the 50s, and I think in the 40s too, that leaked. They rusted through, they leaked slowly, and the heating oil became a bloom that spread out and possibly onto other neighboring properties. So that's a major environmental cleanup. That's a six-figure problem frequently. It's not frequent that it happens, but when it does happen, it's not infrequent that it's a six-figure problem. Then you have other buried hazardous materials that could be on the property, all kinds of fun stuff buried on properties that we've seen around here. The stories go on and on. Um, Another frequent issue that buyers run into problems with Form 17s, and this is the most common one, is structural issues. And the most common among structural issues is water leaking cover-ups. So you've got a seller who fills out the Form 17, and in the entire structural section, no, there's not been remodels. No, nothing has ever leaked. Everything's just fine and normal, just the way we bought it. And then they move in and they discover that roof leaks have happened, water pipe leaks all over the place, shower leaks, sometimes insect infestation, sometimes settling and foundation problems. But the water leak cover up is the big one. And then the contractor comes in and finds obvious examples that there was an active cover up, that somebody just painted over it or drywalled over it or just completely deceived on purpose. And then you've got unpermitted remodels. There's a question in the Form 17 about whether there are remodels and whether the permits were obtained. And those unpermitted remodels abound. So that's another potential frequent issue for a buyer. Uh, so if you're a seller, you also want to avoid pitfalls. You want to avoid these issues. The easiest thing to do is not to give a Form 17 at all. You don't have to give one. It's very common. I hear from real estate agents very frequently that they believe they have to give one because it's not an estate, or I don't know why that is, but you don't have to give one by law. So a common reason to avoid giving a Form 17 is if you don't know about the condition of the property. Um, and a common reason for that is if you are the executor of an estate, you're selling grandma and grandpa's house, you're the trustee of a trust, or you're using a power of attorney to sell somebody else's house, mom and dad's house that you haven't lived in a very long time. So you're not going to fill out a Form 17 typically, and you'd waive Form 17, but there could be all kinds of reasons. You might have a rental property and you don't feel comfortable making assertions about it. You might have a property that's got all kinds of problems, and you know that you've got all kinds of problems, and you're not going to make assertions about the property. You're going to waive Form 17. We draft addenda that are bespoke addenda for purchase and sale agreements that we can work with your real estate agent on to give to your real estate agent. That doesn't just waive Form 17. It's a total waiver of liability regarding the property. Now, the caveat is if you've got this environmental section about hazardous waste on the property and underground storage tanks, things like that. So if you're aware that any of those answers in the environmental section of Form 17, if you're the seller and you're aware that the answer would be yes, then you have to answer those. You can't waive that if you're aware that the answer is yes. But otherwise, you can waive Form 17. Now, what your real estate agent might tell you as a seller is, yeah, you can waive Form 17, but then you're going to reduce your market value. You're going to make people wonder, hey, why are they waiving Form 17? This seems like a normal house. It's not that old. It seems to be in decent condition. Why are we waiving Form 17 here? And you might scare some people off. I can't really speak to that. Talk to your real estate agent. A good real estate agent is going to know when you can get away with not giving Form 17 and when you can't. What I would say is if you're not going to harm your market value, waive Form 17. So then you go back up here. So if you do give one, sellers, I very frequently, like way more often than not, I see Form 17s filled out by sellers with a lot of definitive answers. So the seller is claiming no on a lot of these, when the true answer is I don't know. Of course, if you know the answer to one of these questions about an issue is yes, then you have to answer yes, and then very likely you have to expound at least a little bit on that answer in the section. Uh, uh, in the there's a section near the end where it asks you to expound, and it's not a very big section, and we'll get to that. You can always staple pages to the Form 17 and elaborate, but we'll talk about that. So, um, sellers, if you think the answer is no, think about whether you're totally positive. So we'll go through an example. Form 17 asks, is there any soil or groundwater contamination? This is one of the many, many questions to which I frequently see sellers say, no, there's no soil or groundwater contamination. Well, you don't know that. The only way you know if there's no soil or groundwater contamination, you're guaranteeing that to your buyer. You don't know unless you just did a phase one environmental study on the whole property. Well, of course you didn't do that because it's not asking whether you created soil or groundwater contamination or whether you went out there and did something intentionally. It's in the history of the property, has there ever been, and inside the entire legal description, is there any soil or groundwater contamination? The answer, I'm using this as an example, the answer is you, seller, don't know. You don't know. Um, and unless you're aware that the answer is yes, if there's contamination, then you have to answer yes. Another one, has the classic, has the roof leaked within the last 5 years? No. Everyone answers no. How many little minor roof leaks are out there when inspectors go up into attics and they see like little blooms of black mold, which is like a dirty word. Usually it doesn't matter very much, but then somebody sees it and freaks out about black mold, and there's little spots of slow leak that have never penetrated into the living space, and so there's no notice by the no notice to the seller that they've got a roof leak. They might have a roof leak the moment that they're checking no. Um, and in fact, that's not uncommon at all. I'm using this as another example. So you have these sellers going off and guaranteeing that you don't have roof leaks. So the answer is you don't know, sellers. That's another example, and on for 6 pages it goes about things you don't know. Are all the appliances connected to the sewer? And you say yes, and that should be the most obvious yes in there. But I had a client who sold a property, and there was nothing connected to the sewer because the sewer line between the house and the street, the sewer line was an old concrete line, and it was broken and sagging, and basically the street acted like the septic tank for the whole house, and nobody knew it until they scoped the sewer line, until the buyers in their inspection scoped the sewer line all the way out and went, hey, we just ran into dirt. there's there's a broken sewer line here, which my client had to fix before selling the property, or they chose to fix it in the negotiation. So there's a lot of I don't know there. Um, Finally, with regard to title issues that the seller might run into, the seller, want to minimize your title exposure. Um, there is in the Form 21 of the MLS purchase and sale agreement, which is your standard document for the sale of a single family home, is the MLS Form 21, and it always calls for a statutory warranty deed, and it calls out that statutory warranty deed in the big slew of boilerplate, and I don't like that term in this case because a lot of what's in Form 21 is not boilerplate. It's default language, but it can be changed, and your agent can change it. A lot of agents don't like to change it. That's understandable. Um, but a statutory warranty deed guarantees your buyer a lot of things. We don't need to go into that and get into the details of a warranty deed right now, but suffice it to say that a bargain and sale deed gives your buyer fewer warranties, a lot fewer warranties than a statutory warranty deed, and it likely doesn't affect the marketability. Nobody really cares. Lenders don't care. So there's a lot less exposure for if you've got any kind of title issue, any kind of encroachment issue. If you're, especially if you're selling as a fiduciary, meaning as an executor, an attorney, in fact, a trustee, a guardian, you want to sell with a bargain and sale deed. So if you're going to waive Form 17, definitely sell with a bargain and sale deed. Um, So there are pitfalls for buyers too. So the old Latin term caveat emptor, buyer beware, that's still the default rule. There are more protections for buyers in place now than there were years ago, but that's still the default rule. So watch out for those yeses, buyers. If you see a yes, you have a duty to investigate further. There's a really rough Court of Appeals case. It might be a Supreme Court case. Anyway, there's a rough case out there for buyers where there's a yes, and there might be the the smallest little explanation. Are there any unpermitted remodels? Yes. And then the little explanation is something like kitchen remodel, period. That's all there is. Well, that puts the buyer on the duty of inquiry. Uh, and so the prospective buyer in that inspection period puts him on the duty of inquiry to figure out, hey, what is this? What is this unpermitted remodel? It might be really, really poorly described in Form 17. Again, it might be two words, but if there's a yes, you've got to check it out. And then the flip side of that, if you're the seller, kind of an interesting analysis. If you've got a yes to disclose, how much do you go into that? You're balancing. Well, maybe you want to be super upfront with everybody, but you're also trying to sell a house and have it be marketable. And buyer beware is still the duty. So have you, the seller, complied with your statutory duty? If you say yes, there's been an unpermitted remodel, yes, and then you say kitchen remodel. Well, we've had situations where there's $300,000-$400,000 worth of unpermitted remodels that have to be almost completely undone to get permitted. Um, it's a complete disaster for the buyer, and the buyer, long story short, has difficult sledding to try to pin liability on the seller in those situations. So when you say yes, what do you say after that? That matters. That's something where you might want to consult with us, or have your real estate agent consult with us, because you're balancing marketability against exposure. Um, and then finally, again, pitfall for buyers. Buyers will sometimes, I think in the back of their head, they're going, well, we've got an inspection, and if everything just goes south, that inspector, if it just goes terribly, we'll at least sue the inspector and get our damages for the inspector. And the answer is you're not going to do that. So inspectors uh, limit every inspection contract I've ever seen limits the damages allowable against the inspector. So the worst, the most this inspector could ever be liable for is the cost of their inspection. Um, and that is typically 800 bucks, 1,000 bucks, 1,200 bucks, whatever the cost of the inspection is. That's all you're getting out of the inspector, and frequently they'll offer that right away. They'll say, "I'll give you your money back in exchange for a waiver of liability, but you're not getting any more than that out of me." And that there have been lawsuits against inspectors for unconscionability of that contract, saying, "Well, gosh, you inspector missed the most obvious defects, and there are hundreds and hundreds of thousands of dollars worth of defects, and you just missed it, inspector, and you should have seen it." And the inspector says, "Yeah, that's fine. I'll just admit that, but your damages are limited to this little bit of money you've paid me. It's in my contract." And the Washington Supreme Court has upheld um, that sort of damages limitation contract in the past. And I've never seen an inspector who doesn't have that in his contract. And if you're an inspector, you got to have it in your contract if you don't. So So your inspector's probably bulletproof. That's not where you're going to get made whole. So Form 17, seller's closure statements, all kinds of interesting issues there. If you have a question about them, um, or just if you're in the process of selling, it's worth a phone call to ask about the Form 17. Have your real estate agent give a call. I'm glad to chat. Questions, concerns, there's my information. Thanks very much for joining us.